Welcome to this week's installment of Rochelle's Daily Wire Video Edition. I am Bill Rochelle, the editor-at-large for American Bankruptcy Institute. We come to you the same time at the end of every week to discuss important developments during that week in bankruptcy and corporate reorganization law. This week we have two biggies. One, of course, from the U.S. Supreme Court, the unanimous decision in the case entitled U.S. Bank versus Lakeridge. This decision was ostensibly to tell us what the appellate standard of review is when an appellate court is examining a lower court's decision, deciding whether or not someone is a non-statutory insider. Unfortunately, the unanimous decision by Justice Kagan gave us more questions than it did answers. Justice Kagan told us that to decide whether or not the review is de novo or for clear error, the appellate court must decide whether its work is primarily legal in nature or factual. If it's factual, then of course the review is under the clear error standard. Curiously, there was a four-judge concurring opinion that reached out for the very issue that the Supreme Court said it would not decide, namely, what is the proper legal standard for judging whether or not someone is a non-statutory insider. That concurring opinion by Justice Sotomayor and three other judges laid out a couple of proposed tests. In essence, those four judges indicated that they did not agree with the standard that had been created by the Ninth Circuit. But don't take my word for this. We have just recorded a very interesting, in-depth analysis of that decision with commentary by two professors, Professor Charles Tabb and Professor Drew Dawson. So give that a look on the ABI website. The second issue that I need to bring to your attention is the Second Circuit's decision this week in Henry Anderson. Curiously, a few years ago, the Supreme Court held that arbitration could be compelled in a class action dealing with an alleged violation of the automatic stay. However, the court turned around this week and said that you can avoid or not permit arbitration in a class action dealing with an alleged violation of the discharge injunction. Now, quite frankly, folks, I have great difficulty in analyzing these two decisions and how they fit together if they do. In any event, just like it is with Lakeridge, you can read my analysis of the Lakeridge decision and the Anderson decision on my column, Rochelle's Daily Wire, coming out every morning on the ABI website. Until the same time next week, this is Bill Rochelle saying good day.